Good morning, everyone. This is Margaret Barrett from Safe Harbor Estate Law. Welcome to our webinar, 3 Ways to Plan Ahead for the Second Half of Life. If you're attending today, I expect that you're looking for more information on planning for end of life in Minnesota and Wisconsin. And you're probably here because you're interested in estate planning. Maybe you've never done it before. Maybe you think you need an update to your plan, or maybe you're just confused and you need to know what's the next best step for me. Today's webinar is meant to be an educational program that's helpful to you to help you answer the question, what can I do to protect me and my loved ones? While these concepts apply generally to all the states, today's webinar is going to focus around planning in Minnesota specifically, since this is our primary area of jurisdiction, although we do also plan for Wisconsin residents, and that law is similar. Today's webinar is not meant to be legal advice. It's meant to be educational. If you want to ask me the question, well, what should I do in my case? I'm not going to be able to answer that today directly for 2 reasons. First of all, this is a public forum and it would not be appropriate to answer publicly. And secondly, we don't have an established attorney-client relationship. So this is not meant to be a consult about your specific legal needs. It's an educational webinar. Since we are, a couple minutes into the presentation, I'd like to check out with the audience to make sure the audio and video is coming in clear for everyone. Can you please put yes in the chat if you can hear me and see me okay? And this is just down at the bottom of your page is a spot to enter the chat. And we like you to find that because that's the only way you can communicate with us during the seminar. Okay, I see we're getting a few yeses in the chat. Let me check. Mary. Yeah, Mary, we can refer you to an attorney in Florida if you want to tell us where you are. And if you want to stay for the general concepts, you're welcome to, because they do apply. David, yes. Mary said yes already. Claudia, yes. Sarah, yes. Mary Wright, yes. Felipe, great. Everything's working fine on your side. Bill, Kathy, Palmetto. Okay, so we'll get back to you later. I'm not sure where Palmetto is, but Gabrielle will follow up with you afterward for an attorney in Florida. I know quite a few attorneys down there that I could recommend. Okay, I think that's most everybody. If anybody hasn't, please say yes in the chat so we know that things are working. And it does sound like everything's coming in loud and clear. So if you have trouble later, then it's okay to exit the room and come back in. You could also try your internet connection and your speakers. If you can't figure it out, it's okay, because we're going to send an email with the presentation recording about 20 to 30 minutes after the program is done. That will come automatically. You will miss the Q&A. You won't get to ask questions, I guess, but you'll hear the Q&A. If you don't see this coming after the webinar, check your junk spam folder. Next, it would be helpful for me if you would put in the chat what you're looking for today. Did you have a specific question or problem, something you're wondering about, or what drew you to this presentation? Because then it can help me in the presentation and also even in the Q&A later to better meet your needs. So please go ahead and put in the chat what you're looking for today or any kind of question. So also, we're going to put up a few polls throughout the webinar. You'll see them pop up on your screen, and I'd love for you to interact. And that is really helpful to me as we go so that I can get to know where you're at and what things might need more or less explaining. Now, we generally take about 40 minutes to present and stay on for about another 15 minutes for Q&A that is live. So that's a massive advantage to those who are attending live. People often get the most value out of the Q&A. Keep in mind the parameters I already shared about the limits on giving legal advice in this webinar. And keep in mind, there are no stupid questions. And we've probably heard the question before and are happy to answer it. So, okay, so there's a poll up right now, and just let that keep going. So, thank you again for joining us today. Let me give you a roadmap for where we are going to go. First, in the next 30 minutes, you will learn the 3 ways to plan ahead for the second half of life. Next, you'll learn that estate planning can be smooth sailing. And third, you will learn how to attain the peace of mind and protection that you are seeking. It is attainable. 4, we'll have time for Q&A at the end, like I said. So save up your questions and feel free to put them in the chat as you go, because I will go back to and answer them in the order they're in the chat at first. So feel free to jump in there. Okay, so it looks like a couple of you have been thinking about estate planning for a while, and a couple of you have one outdated, and some have not answered. So, okay. Is this webinar going to be worth your time? I believe it will be if you're worried about leaving a mess behind you after you're gone, or if you're not really sure if you even need an estate plan, or if you are interested in making sure that what you want to happen will happen if you lose capacity or when you pass away. What is really exciting to me about you being here is that if you start taking action on what you learned today, you can get ahead of 75% of the population. That's right, only 25% of Americans have a complete and an updated estate plan. And for some reason, that percentage keeps going down. It's shrinking. So as you take steps to complete your estate plan, you can provide for your loved ones and yourself. You and your family will avoid hassles and stress and expenses, and you'll have the healthcare you want too. So I'm very glad you're here. It's a great first step. Who is Margaret Barrett? Well, I was born and raised in East St. Paul in a family of 8 children, middle child. I'm the owner and founder of Safe Harbor Estate Law, focused on helping clients just like you since 2013. We do planning the right way here with honesty, integrity, very, very thoroughly. We treat our clients the way I want my parents to be treated. Right now we have 12 employees, 3 attorneys, soon to be 4, and we're delivering service at a high level consistently for all our clients. I can relate to my clients because of the personal experiences I have been through in my life. Like many of our clients, I've experienced caring for elderly parents with dementia. My siblings and I worked together to support my mom, who's 90 years old. I was at a cognitive impairment appointment with her last week, and she did well. And we worked together to support my dad, who passed from dementia in 2019. And like some of our other clients, I experienced an untimely, tragic death in my family and a long, difficult, expensive probate afterward. I want to share a little bit more with you about that story to help you understand the kind of things that can go wrong with estate planning. I'll never forget how I woke up Monday morning, March 10th, 1997. I was alarmed because the phone was ringing downstairs at 6 a.m. I was instantly awake as I ran downstairs. My heart was beating, my mind was racing. I remember thinking, well, who's calling? What's the emergency? I answered the phone and I heard Barb, my sister-in-law, and I immediately knew that something bad had happened to my former husband, Joe. That was her brother. Barb said, Margaret, I don't know how to tell you this, but Joey died last night in a car accident. I was so shocked. He was already gone at age 39. It was too late for our children to say goodbye to their beloved dad. It was traumatic and scary. It was a life-defining moment. If you've ever gotten an emergency call or a knock on the door with a message like that, you know what I mean. Next, I braced myself to wake up my son, Ben, age 11, and my daughter, Monica, age 9, to tell them that their father was gone. One of the hardest things I've ever done. These are their school year photos from that year. So much changed for all of us immediately, and for the next several years, much of my life revolved around walking Ben and Monica through their grief and dealing with all the adjustments. But to make matters worse, sadly, the estate was messy, like I mentioned. To his credit, Joe had an estate plan, but there were two problems with the paperwork. First, it was not updated for the changes in his life. He was going through a separation to divorce. And second, it was drafted by a divorce attorney who did just a little bit of estate planning. And we soon learned that there was a critical mistake in how the estate plan documents were signed. These two problems resulted in a lot of hassle, pain, contention, expense, and strained relationships. The legal battle lasted 7 years. It went all the way to the Minnesota Supreme Court. So, in addition to dealing with the grief and the loss, I walked my children through more than 7 years of estate litigation, protecting them as much as I could from it, and over $100,000 in legal fees that could have been avoided or very minimized. I don't want you, your family, or anyone to go through what our family went through after Joe died. This is why I created the smooth sailing system. The system is designed to help you smoothly walk through our process of creating a comprehensive, custom estate plan to protect what's most important to you. If Joe had gone through the smooth sailing system, his documents would have been up to date, properly prepared, and most of the expense and hassle would have been avoided. So I'm interested in hearing from you, and you can please go ahead and put in the chat the answer to this question. Why would you do an estate plan? What motivates you? I know it's something that's hard to get around to, and if we can focus on what our real goal is, I think that can help get it done, even when it's something that's easy to put off, like estate planning. For me, here's a photo of me with my parents when my dad was still alive and my kids. This is who I think about when I think about my estate plan. These are the people I do not want to leave a mess for. These are the people I still want to get together for Thanksgiving after I am gone. Who do you want to protect with your estate plan? What motivates you? Thinking about your goals might keep you moving forward in this process. Okay, and it looks like nobody has had an experience with probate, but one person has heard from others who have. I'm just checking the chat quick, excuse me. Okay. Thank you for answering it. These are helpful input in the chat. So you may be asking now, well, what's the best plan for me? That's a great question. Our goal is to identify your custom ideal estate plan, since estate planning is highly personalized. At the end of the presentation, we're going to have an opportunity for you to speak directly one-on-one with our client intake specialist, Gabrielle, who is on this webinar. And she will give personal attention to your situation and get you started on next steps at no cost in a confidential way. But for now, during the webinar, we'll do the best we can to educate you generally so that you can have a better conversation later about your individual plan. So now that we have the groundwork out of the way, let's dive into the 3 ways to plan for the second half of life. To help you understand the 3 ways, we'll use 3 objects: the slide, the bucket, and the treasure chest. Next, meet Jim and Mary, our sample fictional couple, based on real clients, of course. Jim's 70, Mary's 68. They have 3 children. Jennifer's 44, and she's on Social Security income for a physical disability. Jason is 42. He struggled at times with some chemical dependency And when that happens, he struggles with his handling of finances. Scott is 40 and he's responsible and healthy. Jim and Mary own a $400,000 home in St. Paul. They have $250,000 in retirement, $150,000 in cash and investments, and they own a cabin in Wisconsin that's worth $250,000. They each have a car. They live off their Social Security, their pension, and their retirement. So the first way to plan is a will package, which we liken to a slide, and I'll explain more in a minute. Wills are basic, foundational estate planning tools that are helpful when you pass away. However, wills may not control as much as you think. We use the illustration of a slide with wills because they're quick, fairly uncontrolled method of wealth transfer. Here's an illustration of the will as a slide after Jim and Mary pass on. Picture Jim and Mary's 3 children at the bottom of the slide with their hands out like this mom. And the daughter represents all of Jim and Mary's assets coming down the slide to them. Each child, Jennifer, Jason, and Scott, will each receive their 1/3 share all at once. That may or may not be a good thing. For Jennifer, because she's on government programs, or for Jason, if he may not handle the money well. The will won't protect the inheritance for them in those situations. You have to be okay with that reality when the time comes. For some people, it may not make sense to give the money all at once, but for others, it does work well. Just a brief overview of wills, and then I'll dive in a little further to the things to think about wills. Pros include that you will get assets to the right people most of the time. There are some exceptions to watch for. And you can avoid probate with a will in the right circumstances if the assets are titled properly and the beneficiary designations are correct and there's no problems like what happened with Joe. Third, it works quickly, especially when you can avoid probate. And lastly, it's less expensive than the other main option because it's simpler. Some things to think about is that it controls less than you think, and I'll explain more about that. It does not allow you to add specific rules, and there are risks with transfer and deaths and beneficiary designations that I think it's important to know about if you want to go this route so that you can minimize the risk. So here are some more things to think about. The will controls less than you think. It only controls assets that we say pass through the will. So any accounts that are jointly held or have beneficiary designations will not go through your will. For example, in their will, Jim and Mary could divide their estate equally between the 3 children. But if Jennifer is joint on their main checking or savings account, or if she's listed as the sole beneficiary, then she will own that account and she will not need to share it with her brothers, in spite of what the will says. This fact surprises some people, so I want to make sure that you understand the titling on the account and the beneficiaries trump what the will says. Another way to say this, I just said that, sorry. This is why, as part of the smooth sailing system, we give you clear written instructions on how each asset should be titled and exact beneficiary language. And so you definitely want an estate planning attorney who's going to do that for you. We want your assets to be consistent with your will, not to rewrite your will against your wishes. So if your document is correct, but your assets don't line up with your plan, your documents can undermine your plan. And that is something we see often. And we do all we can to fight against it. Next issue for wills that you want to think about is they don't allow you to add rules that add flexibility and control. And you may or may not want these kind of rules. For example, in a will, you can't say, I want this to go to Susie, but only to be used for college. Or if the money goes to my grandkids, then it should stay in trust until they're age 25. Or I would like my trustee to create a supplemental needs trust for Jennifer so that she still benefits from the money she inherits and she won't get kicked off of her government program benefits. There is not a way to have rules like this in an ordinary will. The third thing that I want you to think about with wills is selling real estate after death. And this can get kind of tricky. Okay, for example, when Jim and Mary die, their 3 children are probably going to want to sell the property, their home and maybe the cabin, to get the cash. And they'll want to avoid taxes by getting the stepped up basis in value after the owners pass away. But in Minnesota, you can't sell real estate until you go through the probate process. Owning property is one of the things that forces a probate. So the house can't be sold until the probate papers are filed with the court, the fees are paid, there's public notice given, there's notice to parties that's given, there's a medical assistance clearance you need, and finally the court issues what's called letters to the personal representative so that they can sell the house. Now, one way around this is a transfer on death deed, or TOD. And usually some of the people in the seminar have heard of this, may even have one. This sometimes works well, and sometimes not. So if Jim and Mary's 3 kids survive, the 2 of them, all 3 survive, and they and their spouses all cooperate, that could be 6 people, they could sell the house without probate and share the benefits. So they all got to agree on cleaning out the house, who's the realtor, listing price, showings, what offer to accept, all that. If they all get along well, it works great. But let's say Jennifer predeceases, her share would probably go to her husband, either under the law or under a will if she has one, or a trust. And normally that is probably not what Jim and Mary want. They probably want the money to go in trust to the grandchildren. So a will not do that for them. Another issue with real estate is that if you, like Jim and Mary, have property in another state, that property will trigger something that's called ancillary jurisdiction. And that requires another probate process for Jim and Mary in Wisconsin. So you'd have 2 probates. So you don't want to repeat the process and the expense of a probate in another state, including notice to creditors, publication, filing fees, legal fees, all that. To avoid that, you would need another transfer and death deed if you have a will instead of a trust. So those are a couple of the examples of where a transfer and death deed might not work for you. So let's go over for Jim and Mary's strategy. They're going to name each other as personal representative, used to be called executor, to take care of their estate after they're gone. And they'll name an alternate backup, maybe Scott. Then they'll give a 1/3 interest to each child in equal shares per stirpies, we say. So, like I said, if Jennifer dies, her share would go to her kids through the will. Then they will name beneficiaries on the documents, which we would direct them on. They would probably name each other first, and then 1/3 to each child. If Jim or Mary becomes incapacitated during life, which is statistically likely, they can act for each other because we would have had them create powers of attorney and healthcare directives. And let's assume now that Jim passes first, and I'm just saying that because he's older. Everything goes outright to Mary if the assets are held jointly or if she's the first named beneficiary. If they have less than $75,000 passing through the will, that means assets without joint ownership and without beneficiaries, they'll need an affidavit of collection to access the accounts. This is much easier and quicker than a probate, and we can help with that. When Mary dies, the second one dies, the remaining assets will go to the kids, mostly outside of probate if the beneficiary designations and the titling is all correct, according to what we instructed them. That's probably not best for Jim and Mary if they're concerned about Jason not handling money well or Jennifer being able to stay in government programs. There's no buffer with the will for them to handle the inheritance well. If they don't have a TOD, then it will take months longer to sell the house, especially since COVID, the courts are a little more backed up. Meanwhile, the kids would be new owners of the house, and so they're going to be paying for the house out of their pocket while they're waiting to get money from the estate. Because you can't use estate assets to pay for non-estate assets. So it's a little bit tricky. So that's how a will plan would probably work for a couple like Jim and Mary. The next way to plan, second way, is a trust package, which we call the bucket. We're talking today about a living trust, also known as a revocable trust. This includes all the items in the will package plus a revocable living trust with some other trust documents. For the trust, we use the illustration, of a bucket because it carries your assets while you're alive and after you pass away. Typically, a married couple like Jim and Mary who own assets together will have a joint trust, and people who have separate assets or are together but not married will have separate trusts. And trusts, for a few reasons, are ideal for blended families. Just checking the polls here. So a couple of you are concerned about protecting assets from the nursing home. We'll get to that. And about loved ones not handling money well. Okay. So just want to make sure I'm up to speed on what the feedback you're providing, which we really appreciate. Okay. Let's go over the pros of a trust and some things to think about with a trust. First of all, you have more control and structure than with a will package. You can do conditional logic, if this, then that. For instance, if my child predeceases me, then the money will be held in trust. If somebody develops a special need, then the trustee can create a supplemental needs trust. All kinds of things like that. Second pro is that the trust is still alive, carrying out your wishes after you pass away. The trust is owning the asset and the trust doesn't die. There's no probate. Third, you can minimize a taxable estate with a trust, particularly if you're married. In Minnesota, there are death taxes or estate taxes if you have over $3 million in your estate. And as a married couple, you can double that to $6 million by having a special kind of terms in your trust. Fourth, trusts protect from creditors, divorce, bad financial decisions, all kinds of things. You can provide for your beneficiaries and still protect against some adverse things happening. Fifth, like I mentioned, you can protect a child with special needs from being kicked off of benefits. And when that happens, if they do get kicked off benefits, essentially your inheritance is just saving the state money. It's not really benefiting your child. Lastly, the trustee has immediate authority to sell property and distribute assets titled into the trust, etc. So they can go ahead and sell the house right away, and you don't have to worry about any of the risks of a transfer and death deed, which I touched on a little bit. Some things to think about with the trust is it is more expensive now to draft because it's a longer, more sophisticated document, and we realize not everybody can afford a trust package today. Next, it takes a little more time to move assets. Remember, I said we're going to give you instructions on titling your accounts and beneficiary designations, whether you have a will or a trust. But if you have a trust and you put your checking account in to the trust, they're going to have you have a new account, which means you're going to have to change your auto payments. That is what takes a little bit longer. We always want people to know upfront what all the pros and cons are before they decide. So for Jim and Mary, what would be a good trust strategy? They would create a trust and both would serve as trustees now, handling their money just like they do now, except it would be in a trust. Secondly, their non-retirement assets would go in the trust now, including their house and their cabin, not their retirement accounts, but their bank accounts. And then the retirement and insurance would go later. So we would craft the right beneficiary designations so that at the right time, those would go into the trust. The trust will give them more options if they're incapacitated or ill. And a couple of you are worried about losing your life savings to the nursing home. this is where we can put in some really great options that, if needed, you can protect half your estate or more. And there's other reasons why. Powers of attorney are not widely accepted. They're often disputed, even though they're required to be accepted. And there won't be an issue with the trustee being accepted by any financial institution as long as you provide the documents we give you. Fourth, with Jim and Mary, after they die, there can be a quick sale of the house and the cabin with no probate in Minnesota or Wisconsin. And 5, the assets will be protected for Jennifer, Jason, grandkids as needed. Pretty much whatever might happen, we provided for in the trust. So the money will still be protected and the kids will still be benefited, and the grandkids, by the money that Jim and Mary leave them. That is an introduction to living or revocable trusts. You probably want to know more about how a trust could work in your situation, or will. And you can start by putting in your questions in the chat now for Q&A, because I'm going to move on. So you might want to put your questions for the trust now so that you remember them. Okay, now let's talk about, there's a check-in here. We just want to see how you're going. We're 2/3 of the way through. And there's a poll that Gabrielle's putting up that just to check in. Yes, some are following, and 3 are somewhat, well, no one's totally confused yet, but if you are, please tell me. So please, again, put your questions in the chat, and we will talk about them at the Q&A. It's always kind of hard when we're not in person. We're doing it over webinar. Can't even tell if your faces look confused, so thank you for putting this answers to the poll. I'm just going to switch back to chat. Okay, now we're going to talk about a third important way to plan, the Medicaid Asset Protection Trust. Okay, put in the chat, please. Yes, if you've ever heard of this, because I bet you haven't. You were probably familiar with the terms will and trust before this webinar, but most people, especially in Minnesota, are unfamiliar with Medicaid Asset Protection Trusts. That's because they've only been officially allowed in Minnesota by DHS since July 2021 Minnesota Court of Appeals decision in the Guyan case, so less than a year ago. Our lead attorney for asset protection and Medicaid, Michael Teeter, drafted part of the legal brief in the Guyan case, arguing that the Department of Human Services disallowance of Medicaid Asset Protection Trusts was unconstitutional under the federal Constitution. And the court agreed with Michael. So he played a key role in this big change in Minnesota law. This is a really big deal. We believe that all the other 49 states allowed Medicaid Asset Protection Trust for years, and now Minnesota residents have this option as well. So what are the pros and things to think about of an Medicaid Asset Protection Trust? The same protections we talked about for the living revocable trust are in a Medicaid Asset Protection Trust. In other words, you can protect your beneficiaries, choose the trustees, how assets are spent, have if-then scenarios. Creditor protection is in there, and including bankruptcy, divorce, etc. So you have all of those. Next, anything that you put in the Medicaid Asset Protection Trust 5 years before you apply for Medicaid is not going to be counted by Medicaid. It will be a successful gift. And Medicaid, by the way, is the state program that pays for long-term care when you run out of money. It's not Medicare, it's Medicaid. So those are the rules you want to qualify for and you want to follow, and they have a 5-year look back. Third, you don't need to spend all your money on a nursing home. You can still benefit you, your spouse, your children, and ensure you get good care, and follow those pesky Medicaid rules so that the state pays their fair share. And fourth, with the Medicaid Asset Protection Trust, the state pays their share sooner. So in other words, if you're able to protect $300,000 in the Medicaid Asset Protection Trust, then the state actually pays $300,000 more. They pay a discounted amount. They pay less than you do, so they might pay $2,000, but they pay sooner because you protected your assets. Some of the things to think about: irrevocable means just that. It's a permanent gift. You're not getting this money back, and you are not the beneficiary of the trust. What people often do is make their children the beneficiary if they have good kids who are going to agree to take the money out to help mom and dad if they need it. But that is not going to be in writing. The written agreement will be that this is not your money. Next thing to consider, you must give 5 years before you apply for Medicaid. If you have to apply before that, we will make a plan and figure out a way to still make this work out. It's kind of complicated, but we can help you do that. Next, there might be other planning options for you. So a Medicaid Asset Protection Trust is just one of the planning options for Medicaid, so that you don't spend all your money on the nursing home, or even home care can be just as expensive as a nursing home. So planning to protect assets and apply for Medicaid is complex and individualized. There are other tools in the toolbox. I don't have time to dive into them today, but we can work with you to sort out how well a Medicaid Asset Protection Trust works for you, and the other options we have to protect your assets, ensure you get good care, and make sure the state pays your fair share, their fair share. Now, I know the difference between revocable and irrevocable trusts can be confusing. So we've created a little visual that will hopefully help you picture the concepts. On the left is the revocable trust. We had it pictured as a bucket before, and this is just a little bit different illustration. So you can see the slide. If you have a trust, the will pours over into the trust in case any assets aren't in trust already. So all your assets are in there, and assets can be put in and taken out of the trust at any time, which is why the lid is off. And with the irrevocable trust, if you see, it's locked on the top. So once you put the assets in, you can't take them out, and they're protected from the Medicaid look back. And then both of these you see has a spigot on it, which is where you would give the money out to the beneficiaries instead of it coming straight down the slide. So revocable, you can think of it as changeable, and irrevocable is unchangeable. An irrevocable trust strategy for Jim and Mary, some ideas for them are they could put the home and cabin into the trust and protect them, and maybe also the $150,000 cash. They could appoint Scott as trustee and beneficiary, and they could then live off their retirement assets and maintain their home. And then if they need care in the future, say 5 years from now, because they're fairly young, then the assets would be protected in the Medicaid Asset Protection Trust, and they won't be required to be spent down. In Minnesota, you have to spend your assets down to $3,000 if you're an individual and $130,000 if you're married to get on Medicaid. So they would not have to spend the assets in the protection trust. When Jim and Mary pass, assets in the trust then will go to their children. During their life, we would be talking to their kids ahead of time before creating this trust about the fact that they can use the assets to give back to Jim and Mary. Particularly appealing, say if Jim passes first and Mary, and he was on Medicaid, that means Mary only had $130,000, which isn't much to go into retirement. She might live another 15 years. And so knowing that she has the money in the Medicaid Asset Protection Trust that Scott will make sure goes for her benefit if needed, that can be a very big plus for her and for Jim if he feels good about taking care of her. So this is an example of a sample asset protection plan. See the pie chart here, the circle graph? This shows how asset planning with our firm can save our clients money instead of all the money going to the nursing home. So plan A would be that whole pie is going to go to the nursing home until you have $3,000 or $130,000 if you're married left, and then you go on Medicaid. That's plan A. This is plan B. And there's some different ways to spend the assets. We can typically save at least 50% of assets for single people and over 75% for married people. And this can be very helpful in caring for a surviving spouse, like I mentioned. One of the strategies is the irrevocable trust, but there's other strategies as well, depending on the situation. And by the way, not everybody qualifies for or it makes sense to do an irrevocable trust plan, but it's well worth looking into. In this case, you can see that Jim and Mary made a gift of $250,000. They brought it out. This is this chart, I'm sorry, is not titled right. So the Medicaid Asset Protection Trust on the left, that is really the gift, the $250,000. And then the rest of the money we ended up spending for care and things like that. It's actually a little more complicated than that, but the point of this chart is just to show that they can save over half their money. Let's do a quick recap now. I've gone through all three of the ways to plan. Probably a little more confused than the last poll, but let's do a quick recap on wills, trusts, and Medicaid Asset Protection Trust. Wills are quick and straightforward. They're the lowest investment. They're the least involved upfront in the planning stage. They work well if you don't have a need for control or protection. They're best for one property or if you're renting, although there can be delays in selling property. And we include powers of attorney and healthcare directives and digital asset authorizations to protect your wishes during incapacity. Trust packages are best if you want to control or structure the way certain beneficiaries receive their inheritance, including minors. They're best if you have multiple properties, so the trustees can sell right away. They protect assets if a beneficiary predeceases you, because of those if this then that kind of rules that can provide for all kinds of contingencies. They're more expensive now, but they have a higher potential to avoid probate. It's like you pay more now, but there's a good chance you'll pay less later in many situations. And we can help you figure out if your situation is one of those. They are more flexible and powerful if you lose capacity than just using the POA and healthcare directive, although we will include the power of attorney and healthcare directive. Irrevocable trusts, these are a brand new tool for asset protection in Minnesota. They are best for pre-planning in case you may need long-term care. They protect assets from Medicaid, and they set aside assets for the next generation while still getting the care that you need. I know we went through a lot of information, and so we'll have a Q&A in just a couple of minutes, and I see we're already getting questions, which is great. But first, I want to tell you that we have set aside, Gabrielle has time on her calendar to speak with you individually about your objectives and our process to see if we can help you take next steps to accomplish your goals. Everything you learned today will help you be better prepared. But as you probably figured out, we've only scratched the surface. So to get some one-on-one confidential complimentary attention, if you click the schedule your call button that just popped up on your screen, you can book a 10-minute call with Gabrielle to listen to your goals, to discuss our process, and determine if our firm is a good fit for your needs. So Gabrielle will set you up with a personalized Zoom or in-life life and legacy session, we call it, with our client relations manager, Dawn Thompson. And she's got time saved on her calendar too, because we know it's best to do this. We have feedback from people who attend the webinar. It's best to do these appointments sooner rather than later, so this new information is still pretty fresh in your mind. So that's why we save time for you. Gabrielle will, in addition to scheduling, discuss expectations moving forward. And if we're not a good fit for your needs, we'll discuss alternatives and make recommendations for you that would be a better fit. You might be wondering, what is the catch? Well, there is no catch aside from, limited availability. We have only 6 spots available for the attendees at this presentation, and I'm doing the same presentation at 4 today. And so we close our calendar after those 6 meetings have been scheduled. So click the schedule your call button now to secure your spot for an introductory call. And once the 6 are taken, we close down the link until our next webinar. And we limit our availability because we want to offer exceptional services to all of you attendees, but also people who are contacting us from other ways. So we need to keep more openings for those potential clients. We know this can be an overwhelming process. I've given you a lot of information. Our job is to help it be less overwhelming. We really want to educate and empower you in your situation about what is best. And that is why we offer this follow-up one-on-one information. As a thank you, when you book a call with Gabrielle, she will send you some free resources that will help you get started with planning that you can do on your own that are going to benefit your family. Okay, I know we went through a lot of information. Now is the time to get your burning questions answered, and we'll stay on for another, we have about 15 minutes to answer your questions. So please keep putting them in the chat, and I will start at the top. Oh, we already had somebody send in a question before the webinar, which is great, but that's at 4 o'clock, so I'll do that at 4. I think, is David the first question? Or do I need to go back further?
Yep.
David, he just said Todd.
He expanded below.
Oh, okay, so that's the same. All right. What if I push on this button? This is answer live. I'm going to try it. David, without a will or Todd, does my house and bank accounts go to my 2 boys automatically in Minnesota if they are listed as 50-50 beneficiaries? Are they minors, David? Can you put that in the chat? Tell me what he says. Okay. Currently, my will.
No.
Your will is not notarized? Ooh. No witnesses? Okay. Your will is not properly executed, David. When a will is not properly executed, it's a kind of a nightmare. And that was partly what happened with Joe's estate. It was actually his prenuptial agreement that was not properly notarized and witnessed. And that's what went to the Minnesota Supreme Court, and it cost an awful lot of money, and it was a big, huge mess. So sometimes having a poor will or document or a poorly executed is worse than not having one. I don't really know in your situation which is worse. I'm really concerned about that. So it will end up probably in court because it's unclear if the will is going to be honored or not. The court will have to decide that. Did he say if they're minors or not?
They're not minors.
Okay, they're adult. Okay. So there's some questions here. I'm going to assume that you and your wife own the house jointly, and I'm assuming that you're the second to die. Because I think if it's joint ownership, you die first, it goes to your wife. Okay, so this is the second owner to die. Without a will or a Todd, there's going to be a probate. And it's going to go, I don't know if you've heard the saying, if you don't have a will, the state has one for you, and it does. And so what the statute would say, if you just have the 2 sons, the house would go to your 2 sons. If you didn't have children, it would go to your parents. If you didn't have parents, it would go to your siblings, etc. So, it would go to your boys automatically, and then they would have to do a probate. One of them would have to serve as a personal representative, and I don't know, most of the people we talk to, the kids are not very happy when that happens, but it's up to you. If you know your boys, how well they would handle that. If that's a really good question, David, let me know if you feel like I answered that. Okay. Well, okay, Felipe, what is probate and why do I want to avoid it? Okay. This is a great question. Probate, you can't take it with you, right? We've all heard that. And when we die, we actually have assets in our name that we own, that we can't take with us. So we have to get them titled in the name of other people. Probate is the court process to get your assets titled in the name of other people after you die. Who gets them? It's up to your will or trust. If you don't have that, the statute, the state has a will for you. So it's a process of transferring them. Minnesota probate is not as bad as, say, California is probably the worst, very expensive, but still, it's expensive. I would say, average, not a real difficult probate, $5,000. It usually takes, especially because you have to do a tax return usually, a year and a half at least. It's a hassle. It's public. Once you file it, you'll start getting solicitations. And the records are available online, so people can see, where each wanted your money to go and things like that. I'd say the number one complaint, wouldn't you agree, that we hear from the surviving families is the hassle.
Yes.
They really don't like the hassle. So there are occasions where we sometimes have clients decide they want to do a probate anyway, or in rare cases, we've actually done it as a strategy, but that's pretty rare. Let me know if that answered your question, Felipe. Also, with a probate, I would add this: all these people get notice. There's all these people who get notice, and you maybe didn't want someone to get notice of a will because you left them out, and they may be entitled to it. So, say a child that you have been estranged from and left out. So, I'm just giving general answers here. In your particular situation, there might be different ones. Bill, good question. I have 2 daughters, one in constant contact, one estranged for many years. Bill, I cannot tell you how common this is with our clients. I'm so sorry. Very common issue. Does the court treat them equally? Well, I'll tell you what, if you don't have a will, yes, they do. Yep. So that's a common reason why parents sometimes hire us, because they'll say, well, I have one who either won't use it well or they haven't talked to me for years. And so, yes, the court will treat them the same. So you really need to make sure you have at least a will, if not a trust, to clarify your wishes. And you don't want to, that's not a do-it-yourself. I mean, I would never advocate a do-it-yourself will, but you don't want to do it with this, because you wouldn't believe how often I had a client, the estranged daughter, out of the blue, we don't even know how she found out he died, immediately sued, and because he left her out. And it was helpful that he worked with us, and I had lots of conversations with him one-on-one, saying, yep, I'm leaving everything to my son, not my daughter, here's why. So in our process, we really protect as much as possible a decision like that. We know that's a really tough decision to make, but we definitely have had clients make them. Okay, David said I answered fine, great. Bill said the one is a beneficiary of my bank accounts and limited stock holding. Yeah, so you're getting into, we'd have to look at all your assets and everything to answer how that would work for you. But if you put just the one on your bank accounts and she survived you and she got it, then it wouldn't go to the other one. So, not sure what you mean about the limited stock holding. Felipe's answered. Monday, May 30th, Memorial Day.
I answered.
Oh, okay. Oh, we had a little mistake in our calendar, I think. Okay, I still have like 5 more minutes or so if you have any other questions. I will say this about the beneficiary designations. I'm not going into all the problems with them now. And Todd's transfer and deaths, they do sometimes work, but there are risks you need to be prepared for. One is people dying out of order. So like, if your estranged daughter died, or someone else died and it goes to the grandkids or doesn't, or whatever, you might, beneficiary designations are not good at planning for that. You can have a couple of, if this person, that person, and especially if we're doing them for you, we'll do as good of a job as we can. But sometimes they don't have as much flexibility as people want and need in some situations. Next, we have seen that financial institutions do not do them properly. So, and then they don't fix them afterward. The money goes to the wrong place. With transfer and death deeds, there was a case, I think it was 2020, 2021, where a guy left his house to his niece, and his girlfriend and him had broken up before he died. And so I think she was mad that she didn't get the house or whatever. So she burned the house down right after, shortly after he died. Well, transfer and death deed, even with that, it's going to take probably a couple months to get it transferred into the name of the next person. I mean, you have to get the certificate of death, and you have to file it with the court. You know, there's a little bit of work involved. It has to be done right. So anyway, the insurance company would not pay on the claim to the niece because she wasn't the insured and she wasn't owning the house yet. It seemed like I thought a horrible, unfair result. But basically, if you're doing a tie, you might want to think about checking to see if your insurance company will cover after you die or will cover that person or will warn them. So that's an example of one of the things that can go wrong. I've seen people do it yourself ones that totally were not done right, and then it didn't go where they wanted it to go. I had one, I'm gonna tell you this quick because I want to tell this story. This woman had 4 daughters, and tragically one died a couple months before her and one died like a month after her. And she had a CD at this well-known large bank, and which is known for, I don't know, having their own rules that they think override the law. So her CD said, to my daughters in equal shares per stirpies, you know, so it would go to her, each daughter gets their share, and if one predeceased her, it goes to her kids. Well, the small print on the CD, the certificate of deposit at the bank said, if your beneficiary predeceases you, they get nothing. So the daughter who died right before her got nothing. Her kids got nothing from the CD. And the daughter who died after her, her kids got it. So completely unfair, not what she wanted. The beneficiary designation was properly written up. Nobody did anything wrong except this language of the financial institution was really unfair and terrible. So that was kind of sad. Now, okay, I don't know if I have time to answer that right now, Bill. We may have to do the one-on-one with you for the question about somebody else that has mental health issues. We are located in St. Paul, right near 35E and 694. We can do the meetings online. There's one meeting, just the signing. We can arrange for remote signing, but we really like you to come here for the signing if you can. But the meeting with Gabrielle, with Dawn can be on Zoom. The big meeting with the attorney, the review meeting can be on Zoom. It's just the signing. Yeah, talk to Gabrielle about the costs. Right. Yes, David, absolutely. That would be a good next steps because it depends on if you're single, if you're married, and we want to talk to you about what makes sense to you. It can be so confusing to talk to you about things that don't. Okay, I think I'll try Bill's question. I don't know if you want me to read it to everyone, but there's a family member with health and mental issues that won't plan. Oh boy, what steps can siblings take to minimize chaos? Oh my gosh, that's a great question. We get calls all the time about family members, parents, siblings, whatever. When you talk to Gabrielle, you can kind of talk to her about that, and she can probably give you some ideas, but there's only so much. Sometimes doing it yourself and then talking to them about it and, giving them examples, we can kind of coach you on that, articles or something. Beyond that, if you work with us and you have a review meeting with the attorney, this big review meeting, that's a good time to talk about it because you'll get more educated about everything in our process. And then I think that I've done that in review meetings before. Obviously, we can't force your brother to do it. I have some ideas about that, but it's outside the scope of this. We have to brainstorm some. Okay, I think that's it. Very good, right? The call with Gabrielle discussed goals and needs, and then she had that longer life and legacy session. That's usually an hour, complimentary, confidential. Dawn's really going to listen to your concerns and tell you the pros and cons for your situation, answer questions, tell you about the process, the costs, so that you are empowered to decide what's best for you. That's the goal of that meeting. 30 to 45 minutes, you said. It's an hour though, but depends on.
And it's all free, so I mean, there's no obligation. We just want to make sure you're educated, like Margaret said. So
I really appreciate all of you being online and staying, and I hope that you take advantage of clicking the schedule your call button to schedule with Gabrielle. I know she's already got something scheduled, I guess, but I always feel a little bit bad. I'm very glad you're here, but I know I'm probably just kind of partly educating you and partly raising more questions. And we want to get you to the point where the questions get answered so you feel like you can make a decision to protect you and your loved ones. So I think that we don't have time for my story, but I just basically want you to know that we want you to have smooth sailing. We don't want you to have experience like I did. We want you and your loved ones to have smooth sailing experience, and you know best what's best for you. And we can answer your questions and tell you what things that you need to think about. So thank you for being here today. We look forward to hearing from you in the future. Bye.